Okay, good morning. My name is Brett Steele. I am the Chief Legal Officer with Habitat for Humanity in Atlanta. We're one of the largest affiliates of Habitat for Humanity International, and I've been with Atlanta Habitat for about 2 years now. Prior to that time, I was the Chief Compliance Officer and Associate General Counsel with Beazer Homes, which is a national home builder based here in Atlanta. Before that, I spent some time with General Electric Energy Corporation over in Marietta, and I started my legal career here in Atlanta with the law firm of King & Spalding, a big firm downtown where I spent several years. My background and experience includes construction and procurement, labor and employment, marketing, real estate, and lots of other things that show up on my doorstep. So I'm happy to be here with you today on behalf of the Pro Bono Partnership of Atlanta. We're going to talk particularly today about risk management and contracts, how to deal with risk in your contracts and your day-to-day contracting matters, and how to balance that risk with the opportunities that come your way in those contracts. Now, I'd like to talk for just a second about what our session today will not cover and it won't focus on. And that's because there are a couple of sessions that other attorneys here in town have already done for the Pro Bono Partnership of Atlanta that are excellent. They're available on their website, and I'll mention those briefly. The first is by George Sewell, who's a local attorney here, and he covered risk management more generally as it relates to your nonprofit. So, more about risk to the organization itself, identifying the goals and the missions of the organization, and how you identify risk and balance risk as an organization on a more macro level. The other is the do's and don'ts of contracting, which was done by John Harbin, who's with King & Spalding, my old firm. And it's a very good tutorial of sort of the basic concepts of contracting, A to Z, nuts to bolts, contracting concepts. But today we're going to do a deeper dive really into the critical provisions you find in contracts that deal with really the highest risk you're going to have depending on what your issues are and what line of work you're in and what you're contracting for. So we're going to dive a little deeper into that aspect of the contract. And so we'll get started. Let me just say initially, though, that the mission of the Pro Bono Partnership of Atlanta is to maximize the impact of pro bono engagement by connecting a network of attorneys like myself and a host of other local attorney volunteers with nonprofit organizations in the area that are in need of free business legal services. And these webinars that are done periodically are one of those services. But they also have a roster of attorneys who are available to help you with particular needs. And I'm sure many of you have taken advantage of that already. The Pro Bono Partnership of Atlanta eligibility requirements: in order for you to participate as a client, you need to be a 501c3 nonprofit. You need to be located in or serve the greater Atlanta area. You need to serve low-income or disadvantaged individuals. And you have to be unable, generally speaking, to afford legal services. You can visit them on the web at pbpatl.org. And I invite you to join any number of the free monthly webinars on the various legal topics that are important to you. You can also check their webpage to view archived seminars and webinars. I've reviewed several of those myself in areas where I don't have as much expertise, and I found them to be very helpful. So I would encourage you to take advantage of those resources. Let me also say that this webinar presents general guidelines for Georgia nonprofit organizations. It should not be construed as actual legal advice, especially from me. Legal advice has to be tailored to your particular need and situation, so you should always consult an attorney to address your particular situation. But hopefully after today, you'll at least be able to know what questions to ask and identify the risk that you might need help with. That's certainly our goal coming out today. So let's talk a little bit about risk and opportunity and just what those are. I mean, in basic terms, contractual risk is the potential for loss, either directly or indirectly, and it's typically financial loss resulting from a breach of the contract or injury to one of the parties or a third party who is subjected to injury as a result of the performance of the contract, can result in financial damages, death, or substantial bodily injury, disadvantage to one party or another that was not anticipated or is more than was anticipated. I mean, it runs the gamut. It's not an inherently negative condition. I mean, we all encounter risk on a day-to-day basis as we walk down the street, and certainly that's the case for every contract we sign. The key is just learning to balance the risk with the reward, and you can do that most effectively when you completely understand what your risks are, so that you can measure those against the reward or the opportunity that you're gaining through the contract. An effective contract is always going to balance the risk to your organization, to your nonprofit organization, with the financial reward you're going to take back in. And that's why it's critical that you be able to understand and be able to explain the risk so that you can make an educated decision about whether it's worth the reward. Effective contractual risk management can be accomplished through a number of mechanisms, and they overlap to a large degree, and so the lines are not clear here, but for purposes of today's conversation, I've tried to break them up into four basic components or four categories, and we'll talk about each of those in some detail. And let me also say we're open for questions at any time during this presentation. Just let our moderators know or speak up, but this is intended to be interactive. So we'll take questions at any time, and we'll certainly take questions at the end as well. We'll open it up for questions. My background, as I described to you, is on the procurement and construction side, and with GE on the large turbine sales and services side. So I've dealt in large-scale contract risk management. But this applies to some degree. These issues apply to some degree in every contract and to every organization, and so this is a universal concept. So the first of those I like to call risk transfer, and that includes insurance, which we're all familiar with in its various forms and iterations, and indemnity, which means another party, typically the party to the contract, has agreed to assume or take on the risk that you might otherwise have in the contract by indemnifying you against certain risks. The second category is risk avoidance. You can think about that generally as releases that you might have third parties sign. If you have volunteers, for example, who do work for your organization, you might have them sign a release before they begin work, basically releasing you from potential claims or harm that they might encounter while they're engaged in their work. A good example for us at Habitat is our volunteer work for those who work for us on the job site building the houses. We build our houses in 7 work days, and we do that with a lot of volunteer labor, which we're very appreciative of. But due to the nature of the work and our risk profile, we ask those volunteers to sign a waiver when they come on the job site to do work for us. So that's a release and a waiver. Those go hand in hand. Those are 2 risk avoidance techniques we use. The other is through the use of subcontractors who may perform certain work for your organization. For us, we hire a limited number of subs, for example, to pour foundations and do electrical work, things that we don't have the expertise to do, and volunteers, we don't want wiring houses. So we hire subcontractors to take on certain obligations, and with that, they take on the risk attendant to their work. So we avoid the risk and or transfer the risk to those subs through those subcontract agreements. The third bucket is risk minimization. And you can think about that in terms of being an additional insured, for example, on a contract, or placing damage caps on the types of damages and the amount of damages for which you might be liable under a contract. And we'll talk about both of those in detail as well. And then the last, and I don't want to minimize this because it's very important, is just risk acceptance. You may find that if you go through the first 3 categories and you try to come up with a way to insure against a particular risk, or ask a third party to insure you against that risk, or add you as an additional insured, or give you a waiver, or indemnify you, and it just doesn't work for any number of reasons. Maybe they're not, they don't have a risk profile that allows them to take on that risk. you may find if you step back and really look at what your risk tolerance level is, that you're able to accept the risk, either by adding a price to the contract or subcontracting that aspect out to get another third party, pricing it in somehow. But I don't want to lose sight of that, because there are often times when you deal with very large companies that you don't have a lot of wiggle room to negotiate some of their form contracts. So you have to be creative in terms of finding a way to get a deal done, and oftentimes it may include accepting some part of the risk. Any questions about those concepts on sort of a big picture level? Okay. Okay, great. Okay, so if we get a question, they'll let me know, and we'll dive into the question. So let's talk about the first of those four buckets, and that is the opportunity to transfer the risk. The most common way to do that is insurance, which we're all familiar with because we've all got to have auto insurance, homeowners insurance, etc. Insurance is simply a contract where one party, the insurance company, for a fee agrees to compensate the other, you or some third party, facing a risk of financial loss as the result of a triggering event in the contract. You're just paying someone else to accept the risk of your potential future liability. Now, in terms of the sort of contracts you're going to deal with in your day-to-day business operations, the most common insurance you're going to deal with, either as an insured purchasing your own insurance or dealing with a third party or subcontractor, is commercial general liability. That's the most common all risk insurance. Any company of any size is going to have some type of CGL policy. $1 million, $2 million limits are pretty standard there. $1 million per occurrence, $2 million in the aggregate. That's a base level of insurance that any organization of any size is going to have, and it's pretty reasonable unless you're in some sort of very dangerous enterprise. The second common type of insurance you're going to see, and you're going to certainly require your subcontractors or people doing work for you to have, is going to be workers' compensation insurance. You want to always make sure that subcontractors doing work for you on site or otherwise maintain workers' comp insurance, because that's the protection you have against injury to their employees. If they've got valid workers' comp insurance, that's a shield for you against claims for injury to those employees as a result of work being done for you or on your behalf or at your job site. So there may be limited exceptions to that. An easy example might be an independent contractor you hire to come in and do work for you as a sole contractor, someone who comes in your office and helps with the marketing work. They work 20 hours a week. They only work for you and or maybe one other organization, but they don't have employees. They're not doing anything inherently dangerous. They're sitting at a computer and it's just them. There may be times where you don't require workers' comp insurance for employees or for contractors like that, but in most instances you're going to require workers' comp of your contractors or your trades. And then directors and officers, D&O insurance is another common type of insurance most organizations and nonprofits maintain. It covers your directors and your officers, so your board, which is typically a volunteer board, and your executive team, your officers, are covered under D&O insurance, generally speaking. And many times you're going to want to make sure that organizations with whom you contract have that insurance. But that's a conversation you ought to have with your attorney, but it's certainly something to be aware of and have on your checklist. Lots of other types of specialized insurance that's available and may be necessary, really depending on the type of organization you are or the types of work you're having done by third parties or contractors. A hot area of insurance these days is data security or data breach insurance. And if you've got confidential information, you have third parties servicing that information or providing access to that information or a portal to that information for third parties or customers, you really want to take a look at what sort of protections they afford you in your contract, either through data breach insurance or indemnification and or both, really, because we all have seen the class action suits over the last few years against Target, a number of other large retailers for breach of consumer data. It's a really hot area, hot topic. It's a hot topic internationally as well. So when you're protecting your data, or if you are a nonprofit that's in the business of servicing data or coming into contact with data, you really want to pay attention to that type of specialty risk insurance. There are others. I could go through a laundry list, but I just wanted to hit the high points and make you aware that insurance is probably the most common risk mitigation tool out there, and take advantage of it both on your end and when dealing with third parties, when contracting with third parties. Any third party contractor that's viable, in my opinion, has base level insurance, and you ought to talk about what coverage they have and how you get added as an additional insured, and make sure that it covers the risks that you see in dealing with that contract. Along those same lines, in the transfer bucket, is indemnity/hold harmless coverage, and that's basically a provision in the contract where you've asked the third party, or the third party has asked you, depending on the risk, to reimburse them or to cover them if there is a particular damage or loss under the contract. Lots of times you see it as it relates to damage to third parties. You or the third party with whom you're contracting will ask that you indemnify one another for certain types of risks. But indemnity, hold harmless, most people use those terms interchangeably. There may be differences under the law in certain jurisdictions, but the concept is the same. Let me also mention that a critical component of the indemnity, hold harmless concept is the duty to defend. And you can think about that as the indemnity, hold harmless piece will reimburse you for any damage you incur that's covered under the indemnity provision. So if they indemnify you for third-party injury on your work site, for example, and the third party is injured and sues both of you, if there's an ultimate verdict against one or both of you, and the verdict includes damages against you, their obligation is to indemnify you for that damage, meaning they will reimburse you whatever out-of-pocket costs you incurred as a result of that loss. Equally important, maybe more important in many instances, is the duty to defend component. And that's not automatically inferred just because you have an indemnity or hold harmless provision. You need to make sure the language of that provision includes the duty to defend. What do I mean by duty to defend? I'll give you a good example based on my background, and it was particularly prominent at Beezer Homes. Most large home builders don't own a hammer, as the saying goes. They don't build their own houses. They subcontract all the work out. And when you're building several thousand homes a year, it's not at all uncommon to get sued, several hundred times a year sometimes from homeowners for everything from minor issues to class action suits in some instances where you may have used faulty drywall, for example, that was manufactured in China. There was a suit a few years ago against a number of large home builders for faulty drywall that was built in China. But you always, as a builder, when you sign agreements with subcontractors, you ask them to indemnify you for the work they do on the house, and you also ask them to defend you in the event you're sued for their faulty work. And that's critical because 95 times out of 100 lawsuits against builders are settled before they're tried. So the real and when they're settled, the third-party subcontractor is going to pay the damage directly because they have an indemnity obligation. But it may take 2 years of litigation, sometimes with hundreds of homeowners suing you, to get to the point that you can settle the case. And you may incur millions of dollars in legal fees to get to the point where you can settle the case. If you don't have the duty to defend coverage by that subcontractor, you're going to be paying those legal bills out of pocket. And you may not recover those on the back end. You may or may not, depending on the language of the indemnity and the law in that state. But if you're spending several $1 million over the course of several years to defend yourself, lots of times that's going to dictate the parameters of settlement, whether you really have an obligation under the law or not. You're spending so much to defend yourself that you may settle for more than you think you should, or you may settle out for the subcontractors. But when the subcontractors have the duty to defend, or the third party has the duty to defend, they're paying your legal fees as you go, typically. And so that's a very powerful tool to help with your bottom line and to make sure that you're not on the hook for out-of-pocket legal fees that can really bleed the coffers of your organization, and that's especially true with a nonprofit organization. So if you're having work done on your property, or you're building, or you're adding on to your facility, or you are in the work of building, as Habitat for Humanity is, it's important that you have that duty to defend obligation from your third-party contractors, because oftentimes that's more valuable than the actual indemnity piece. So, okay. Sure. Okay. That's a great question. So the question was, how does indemnity and the duty to defend, how do those work in a charity event, maybe a fun run or some sort of event where you're bringing in a third party to coordinate and run the event for you? It's a great question, because I think I have a pretty good answer, because we had a similar issue crop up within the last year for us. We had a fundraising event at a local brewery, and the contract that the brewery sent us, they sent us their form contract. We hired them to run the entire event, to provide the food, obviously the beer at the brewery, but to also provide the servers and the bartenders. And the form contract they sent us placed the risk of someone being injured or something happening as a result of the event and the service of the food and drinks at the event on us as the contracting party, as the party hiring them out. And I mean, I had to read it several times. I thought, surely they've got the indemnitor and indemnity switched up here. This can't be right. This is not what they intend, because why in the world should we bear the risk that they overserve someone, or that the food poisons some person, or that someone is injured in the process of attending their event at their facility? So we reached out to them. We had conversations with their business contact, and not surprisingly, they didn't, they were not familiar with the language, and so they balked a little bit initially, because they're sort of used to getting their way. It's their form contract. But we eventually were able to massage that and get it to their outside firm. And after a conversation, we were able to resolve it, and they agreed that that's the risk they ought to bear, for a couple of reasons. It doesn't make sense that intuitively, it doesn't make sense that we would take that risk, because we're not we don't have the ability to control it. We're not serving, and we're not hiring or selecting the servers. But I mean, from a risk-reward standpoint, the point I made was, you guys already insure against this. You've got dram shot coverage. This is your brewery. You serve every day. You're not serving for us as a special occasion. I mean, it's a special occasion for us, but you pour every day in here. So you already have coverage. You don't have to pay anything to cover this event, and they could call their insurer and confirm that was true. So we had a conversation about risk-reward and who ought to bear the risk versus the reward, and they agreed. I mean, they were reasonable, and it didn't make sense for us to go out and procure a one-off policy to cover that risk at additional expense to us, which we would in turn expect to recoup somewhat in the contract. So, to answer your question there, I think you just have to, if it's a reputable company and they're in the business of providing that service, that's something they ought to cover. And if if they balk initially, or if they just don't want to be bothered with negotiating what they call a form contract, take it or leave it, you just have to keep gently poking and prodding and say, I really think that we can resolve this if we can talk to the right people, if we can talk to your counsel, and everyone understand and talk about what the risks are here, and who ought to bear those relative to, who can insure against them or who can afford to cover them. So it's just, it's really a conversation you have to have. But I think that was a great question, because that's a recent example we had where we were able to successfully transfer that risk and they could bear the risk at really no additional cost. One other pointer I'll mention here on transferring risk is, you can't get greedy. Maybe that's the point here is, if you're going to ask someone to indemnify you and cover you against every loss under the sun, including your own negligence or willful misconduct, even if you have superior bargaining power and you might be able to twist their arm and get them to sign up for that language, you got to be careful, because a lot of states, to mitigate against that very risk that people have unequal bargaining power, they will limit by statute the scope of the indemnity. And most commonly, you see that the state law or the state statute says you can't ask a third party to indemnify you against your sole negligence or your willful misconduct. You can control that; they can't control it. So we're not going to allow you to do that. So that's just something to keep in mind and have a conversation with your attorney about when you're negotiating those provisions. But in many states, that can be an issue. I'll just also mention, while we're on the topic of indemnity language, there is a wide spectrum of acceptable language. On the one end, you've got broad form indemnity, as it's commonly referred to, which is along the lines of what I just described. You're basically being asked to, or you're asking a third party to indemnify you against all claims that result from the work of that contractor and their subs, their affiliates, their officers, agents, employees, regardless of the acts of third parties, including you, to some limit, maybe not for your own negligence or willful misconduct. But it's not uncommon. You see it a lot, especially if you've got a sophisticated contractor on site building you a $50 million facility. You're going to ask them to take on a pretty broad obligation to you, because they're controlling that work. They're controlling the subs. They have the expertise in building plants or building new facilities or additions to your building. You don't. So you're going to ask them to take on a broad form indemnity obligation. Along that spectrum, on the other end, is very limited form indemnity, where you might agree, or a third party might agree, to only indemnify you for claims that result from and are only to the extent of your willful misconduct or your gross negligence. And in fact, you may see those two work together. The broad form indemnity that you get from the general contractor who's building your building may dovetail with a limited form indemnity you provide to that contractor that says, look, you provide broad form indemnity for everything you and your agents do on my job site, and I will in turn agree to carve out of that any damage that results to the extent of and directly as a result of my willful misconduct or my gross negligence. And you might marry those two together, and you've got indemnity from both parties that works, because you've effectively balanced the risk and reward given the sophistication of the parties and the work to be done. All right, the next bucket we'll talk about is avoiding the risk. And the first concept I'll get into here is the idea of the waiver of subrogation. And from a definitional standpoint, that generally means the voluntary relinquishment prior to the loss, and that's key, by a named insured of the right to seek reimbursement or other legal remedies for a claim or debt paid on behalf of another. And this waiver of subrogation works hand in hand with indemnity, and it's binding on the insurance company. And let me tell you why this is important. If you get that third-party general contractor to indemnify you against certain loss, and they've taken on loss that results as a result of anything done on site while they're there, you've got to have the waiver of subrogation hand in hand with that, because if you don't, what it allows is the third-party contractor to cover your loss, but then their insurance company on the back end to sue you to recover for any portion of that loss that you caused, because they are insuring the loss that the general contractor has indemnified you against. So they pay out $100 million or whatever it is for the collapse of your new facility, and that money's coming from their insurer. They're either going to pay it directly and get reimbursement from the insurer, or the insurer is going to pay it directly. But then if you don't have a waiver of subrogation, the insurance company may come back to you and say, hey, you were responsible for some portion of that damage, and we want you to reimburse us because we've paid that damage now, $100 million, most of which went to you, but some of which went to third parties, you were responsible for some portion of that, so we want you to reimburse us for some portion. You want to avoid that conversation and that fight with the insurance company. Insurance companies are well aware of waivers of subrogation. They're common in most commercial contracts, so it's not a surprise to them. And if it's in there, they're typically bound by it. In all but the rarest situations, if it's in the contract that you signed before the loss occurs, even if they don't have knowledge of that particular contract signed by their insured, they're bound as the insurer by the waiver of subrogation. So that the second bullet there is just more explanation of the concept of the waiver of subrogation. The insurance company entitled to stand in the shoes of the insured and recoup the loss they paid out. The next bucket we'll talk about a little bit is minimizing the risk. And you can do that a number of ways, and we'll talk about a few of those here. The first is being named as an additional insured on the insurance policy. And the way that works is you ask the party with whom you're contracting to name you on their insurance policy as an additional insured under the policy. If you're indemnified in the contract, you're going to want to ask for the additional insured status to make sure the indemnification obligation is backed up by something. As a practical matter, that's important because the indemnity you get from the third party or the person you're contracting with is only as good as the funds they have to back it up, either resources in their coffers or more commonly insurance. So you don't want the indemnity coverage unless they're backing it up with an insurance policy. And you want to make sure that insurance policy is going to tie in through the additional insured status that you're granted in the contract. That's also a very common term in an agreement. That won't be a surprise to anyone if you ask to be an additional insured on their CGL coverage or whatever policy you're negotiating. It won't come as a surprise to them or their insurance company. In the building arena, for example, subcontractors, they name additional insureds all the time. And it's just they make a phone call or an email to their insured to let them know that they're doing work on a new project for a new owner and that they need to be listed and added as an additional insured. There's no additional cost to the contractor. So, again, we talk about who's in the best position to take on that risk when you balance the reward in the contract. It doesn't cost them an extra dime to add you as an additional insured in most instances. So it makes more sense for them to insure the risk through an indemnity obligation and adding you as additional insured than it does for you to go out and buy your own standalone policy when you're not in the business of, for example, building or insuring against a builder's risk. Some of the additional benefits here we talk about, typically that's going to provide an immediate defense to you. We talked earlier about the duty to defend. If you are an additional insured status, you stand in the shoes of the primary named insured, which means if their insurance policy covers the duty to defend and provides an immediate defense, you're going to enjoy the same coverage. So your defense fees will be picked up from day one, $1, which is a huge benefit, especially to a nonprofit. Not having to pay those out of pocket and then wait 60 days, 90 days, 6 months for reimbursement is very critical. Let me mention a couple things you need to be aware of, though, potential drawbacks, and you just need to be mindful of these when you're asking to be added as an additional insured. It's not a panacea in the sense that it doesn't necessarily provide you absolute coverage for all types of potential contractual liability. What I mean by that is you are subject to the same limits of the insurance coverage and the exceptions. And if any of you have read insurance contracts, you know that the first page of a 200-page insurance contract describes the coverage you're afforded. The next 199 pages covers the exceptions to coverage. So you got to be mindful of the exceptions. But the point there is you only benefit as the additional insured to the extent of the coverage in the policy. So you're going to want to make sure that you've analyzed that insurance policy, the third-party contractor, and that you're comfortable, or your insurance agent is comfortable, that it's going to cover the type of risk you are being indemnified against in the contract. A similar concept there is that certain acts that may be prohibited in the insurance policy that would cause a denial of coverage, some some willful or intentional act, for example, or lack of due diligence or failure to do certain things by you or the primary insured may cause coverage to be denied. So you just need to be mindful of that as well. Those are some of the limitations and drawbacks that you need to think about as you negotiate additional insured status. Along the same lines, in the minimize risk bucket, limitations of liability. If you find yourself in a situation where you've negotiated the best deal you can with this third party, you've asked for additional insured coverage, and you may have gotten it in some areas, but you still have some risk under the agreement, or you've been asked to indemnify them in some limited situation, you want a limitation of liability provision in the contract, and those are standard, and they're probably going to ask for the same thing. But basically what that means is, even in an instance where we are liable to you under this agreement because we've agreed to indemnify you or cover or take on certain things, there's a cap on the value of that obligation to you. Okay? You're either waiving certain types of damage, punitive damage, consequential damages, and or you're capping the total dollar value of the liability you have under the contract. And let me give you probably the easiest example to understand there. When you call a termite inspection and treatment company out to treat your house for termites, you pay them $500, $800, $1,000, whatever it is, and you sign that agreement with the contractor. When you read the contract, their liability to you, if there's a reinfestation of your house or your house falls down from termite damage, their liability is capped at the value of that termite contract. So if you paid them $800 and they missed an infestation, or there's a reinfestation because they've negligently treated you, you're only going to get back what you paid them for that treatment. You're going to have to look to your homeowner's insurance for additional coverage. That's the best example of, at least for the termite contractor, a very effective limitation of liability. And those are non-negotiable, and they're typically not going to take on any obligation beyond that. You might get a termite bond that's separate, that would add some additional coverage, but at least as to their liability, they're going to cap it at the value of the contract. And that may seem harsh, but in all honesty, in most service contracts, if you're buying software as a service or you're buying something as a service, most of those have a similar provision. They're going to cap their liability unless you negotiate around it, and many times you can and should, or negotiate for additional coverage, but they're going to cap their liability at the value of the services they've provided as calculated by what you've paid them to date or what you owe them through the term of the contract in the best case scenario. So just beware of those provisions. They can benefit you if you find yourself in a position where you're taking on certain liability. It's going to be a benefit to you to negotiate a limit on that. But on the other hand, beware that oftentimes the party with whom you're contracting is doing the same thing. They're limiting their liability and capping it at a dollar amount or limiting it to certain types of claims. And you just need to be aware of that so that you can be covered in other ways if you need to. The other thing I'll mention, lastly, is an excess liability provision. I don't want to get too far in the weeds on that, but basically what that is, it requires a party that's indemnifying and providing additional insured status to have their insurance declared as primary and non-contributory. This will allow you to protect your insurance and the limits of coverage, and it limits your insurance coverage to excess participation. What you don't want to have is a situation where there's a fight about which insurance ought to cover a loss. The third party's insurance that you've been added to as additional insured, or your primary insurance. And you don't want to the general idea is you don't want to draw down on your insurance coverage until that additional insurance coverage is exhausted. So that's what I mean there. Just beware of that. It's a topic you ought to have a conversation about if you find yourself in a situation where you think there might be competing claims on two insurance policies. The last of the four buckets we'll talk about briefly is accepted. And I mentioned up front that this is the less obvious of the four, but it's certainly not one that should be overlooked. Price, when all else fails, when you can't negotiate a favorable outcome with the third party with whom you're contracting, you can't sub it out, price for it and charge for it. If you can take it on, if you think it's covered under your insurance policy, or if you think the risk is minimal, or you think it's something you can afford to take on, price it. Price it accordingly and take on that risk and don't lose the opportunity. As a practical matter, I think you ought to exhaust every opportunity and every avenue before you walk away from a deal that would be good for your organization. You can charge for it by pricing it in the contract. You can also, I'll mention, maybe buy a one-off policy to cover it and charge for it that way. Price that into the contract. Buy a special events policy coverage for that one event. If you get a brewer, for example, who's not as flexible as ours was when we contracted for our event, if they just are not willing to move because they don't understand the risk or they don't want to take it on, price it out. Buy a one-off policy to cover that one-time event and, charge them for it or back it out of the contract. Hire a third party who can take on the risk, who specializes in that risk and who can take it on. And that's another example of pricing the risk in and charging for it. I'll give you an example of that. We at Habitat we have what's called a repair with kindness program. We go out in the community and we repair existing houses that maybe elderly people are living in, where they have a critical need for repair. We do roof work, interior work, anything to make the house safe, accessible, and dry. But we don't do mold remediation, and we make that clear up front, and we make that clear in the contract with the homeowners. And the reason is that's a very specialized area of work. It's very risky. There's a lot of hysteria out in the world about mold and mold risk. Most of it unfounded, but it's out there. And so we make clear that we don't do mold work. If we find mold work when we get into a house, we back out immediately, and a third-party mold remediation specialist has to be called in. So that's how we price that risk. Essentially, as we say, we're not touching it. There's no dollar value for us that will make us touch that. But there are mold remediation companies that you can hire, or that the third-party sponsor here who's paying for your repairs can hire. When the mold is remediated, when we get a certificate from that company that it's done, we'll come back, we'll resume our repair work. But that's a risk that we can't accept directly, but we find a way to price it in and charge for it, essentially by taking that out of our work scope, putting it off on a third-party specialist. Let me just mention a few other factors to consider here, and I'll be done with my remarks, and then we'll take any more questions you have. A few other things to think about when you consider allocating risk in your contracts is who's in the best position to control the risk. And I go back to the example with the brewery because that's just the easiest one, I think, to conceptualize. But they're in a much better position to control the risk of drunk drivers leaving their party or as a result of being overserved, because they employ the bartenders. They screen the bartenders. They make sure the bartenders are adequately trained. They've got dram shop insurance coverage, which is the name of coverage you get to cover risk of alcohol-related injury. So they're in the best position to cover that risk, and they, it's almost certain that they've already priced it into their operations. They've got dram shop coverage. They've got CGL coverage. They've already paid for that coverage, so they're in the best position to cover that risk. The second thing to be aware of always is the knowledge of the risk. I mean, does one party's knowledge and understanding of the risks that you're negotiating make them a more logical party to assume the risk? Go back to the mold remediation specialist we just talked about, or go back to the general contractor who's building an addition on your house or your facility. That's their work. That's what they do every day. So they have a much more developed understanding and appreciation for the risks that are attendant in mold remediation and building on additions, for example, than you do. And it makes sense that they ought to take on that risk. If there's a price for it, that's fine, price it in, but most times it's going to be covered already in their insurance. And you want to make sure, as we talked about earlier, you are an added insured and you're indemnified, etc. Beware also of the legal limitations we talked about. Statutory and common law may limit the types of risks you can transfer. The example we talked about most commonly is you can't always, in many jurisdictions now, ask the other party to take on damage or breach that results from your sole negligence or your willful misconduct. Think about the custom and practice in the industry. I mean, what's customary? Who normally takes the risk that you're dealing with here? Have a conversation about that. If you're in the best position to know because you're signing up a new vendor who is performing work that's within your mission, you're going to have a very good understanding of what the custom is. If you're hiring a general contractor to come in and build you an addition or build a new building, you probably need to talk to an attorney who's an expert in that area who can help you understand what's customary in that area and what types of coverage and risk allocation tools are typically utilized when managing those types of risks. And then lastly, this is always the case, right? What are the respective bargaining positions? I mean, what's your size relative to the party with whom you're contracting? What's the level of competitiveness in the marketplace? Can you go somewhere else very easily and get another contractor to do the same work and take on the risk or provide the insurance or indemnity you're asking for? But that's always a factor, and don't discount that. I guess the last thing I would say is to summarize all this. I know we've covered a lot, and these can be fuzzy concepts, and they're tricky, and lots of details here, and there's a lot of overlap among these four buckets. But I would just say to you that in contractual risk management, insurance, indemnity, and limitation of liability are really the holy trinity. Those are the three concepts you always should be mindful of when evaluating your risk under a contract, and they always overlap. They're interwoven, and when you look at one, you have to look at the others and decide how they work together, how they mesh together. We talked about some examples earlier, but you always got to be mindful of all three as you effectively mitigate your risk. Each is relevant to the other. You've got to always evaluate them in conjunction with the other. And when you understand those and you look at all three in the context of the entire agreement and the relationship between the parties, you're going to be in the best position to allocate your contractual risk and maximize the opportunities available to you under the contract. And with that, we'll turn it over to you guys. For those of you who are not asleep, if you have questions or comments or any sort of input or feedback, we would welcome that.
One question, Brett. Talk a little
bit
about the limits on transferring wills from certain states. What are the rules in Georgia limiting the transfer of wills?
I'll give you the high level, but I won't. I hesitate to get into that in any detail because again, this is general advice, and you really ought to talk to one of the excellent attorneys that are on the panel here with the Pro Bono Partnership or your own outside attorney. But generally speaking, Georgia follows what is now the majority rule. They limit your ability to pass on or transfer your risk to a third party for your own sole negligence, your own willful misconduct. Those are the general parameters in Georgia and most states now. And last call, that looks like our last question. Is anyone else out there got any questions or any feedback? If not, I appreciate your time today. I don't often get asked to speak on these topics. They're very interesting to me and always have been, and I've worked in these areas for 20 years now, so I get excited in talking about this, but most people don't share that enthusiasm. So they can be a bit mundane and dreary when you get down in the weeds, but I do appreciate your time, and I hope this has been helpful in just giving you a little better perspective so that not that you can negotiate these on your own, but at least you know now what to look for and what questions to ask, and maybe you know enough to know when to get some volunteer assistance or talk to outside counsel so that you make sure you're covered. And with that, we'll sign off. Thanks again, and have a great day.